We are live.
We are live. Good morning. This is Senate Judiciary, Thursday, March 30th, 2023. And we're taking up H53, an act relating to driver's license suspension, which ages me because I think for the last 20 years, we've been dealing with this problem. And so I'm glad that the House took it up again, and we're dealing with H53 and Zia Dexter Cooper, who's going to walk us through the bill.
Sounds good. So for the record, Anthea Dexter Cooper from the Office of Legislative Counsel. I don't get to be with you all that often, except for the small bits with the driver's licenses. So as your chair was saying, there have been a number of efforts to address driver's license suspensions over the years. One of the things that's posted to your committee page, and I'm not going to go through today, is just sort of a brief history of some of those legislative efforts over the years for those of you who are new to the committee and the subject matter area. The bill itself is both short and I think very straightforward, and it would be shorter if there weren't a number of technical corrections in it, which your members that are on Senate Government Operations have already heard about this week. So in general, the big picture of what this bill does is in 2016, the General Assembly eliminated suspensions for the non-payment of all traffic violations. So now the only suspensions related to non-payment, not related to driving behavior, are ones that are for the moving violations, a traffic violation where there's an imposition of points. And this would eliminate those suspensions for non-payment. It doesn't do anything to change suspensions for the accumulation of points, suspensions related to negligent operation, which is an immediate suspension, or the non-payment of child support, which is federally regulated, for DUIs, things like that. It's really just you didn't pay your moving violation and your license is suspended. That's what this bill does. So walking through the language in subsection B and the subsection heading, it's simply changing the subsection heading. Oh, and my share content's not up, so you can't see what I'm talking about. One second. Let's try that again. There we go. So your subsection heading in subsection D is changing. Since there will no longer be suspensions for non-payment of certain traffic violations, the subsection heading shouldn't say that. Instead, to be more encompassing of what's in subsection B, it's referencing payment plans. The substance of this bill is the striking out of subdivision 2A. I know that's really hard to read, so I'm actually going to show you what subdivision 2A says unstruck out. So basically everything that you see on the screen is what this bill strikes out. So under current law, in the case of a judgment on a traffic violation for which the imposition of points against the person's driving record is authorized, so moving violations, the judgment needs to contain notice that failure to pay that judgment within 30 days of the notice will result in suspension of the operator's license or privilege to operate. So that's the notice requirement. No longer needs to provide that notice since there wouldn't be suspensions. Step 2, under current law, if the defendant fails to pay the amount due within 30 days of the notice or by a later date if it's determined by the Judicial Bureau, then the Judicial Bureau needs to send notice to the Commissioner of Motor Vehicles of the non-payment. So step 2 is the notice of the non-payment from the Judicial Bureau to the DMV. And then step 3 is if after 20 days from that notice being sent, the commissioner still hasn't received, there hasn't been payment on the moving violation, and then the commissioner suspends the operator's license or privilege to operate for 30 days or until the amount due is satisfied. So all of this would be struck out. No longer providing notice of the possibility of suspension, no longer having the Judicial Bureau notify the commissioner of non-payment, no longer having the commissioner actually then suspend the license. The other change that you'll see in these next two, while I'm going to talk about them because they're not really technical corrections, are probably not a change in practice. And those are the fact that the offering of a payment plan, I think in practice, the Judicial Bureau offers payment plans. Under current law, it's only to avoid suspension, but since suspension is no longer a threat hanging out there, the other amendments in the bill go through. That's not something that would need to be notification of, but so that you know, the current payment plans are to pay not more than $30 per traffic violation per month or $100 per month, and that would be if there were 4 or more outstanding judgments. And then the final piece to talk about is a change that's not a technical change, but probably is a clarification of current practice, is in order for there to be civil contempt proceedings, this explicitly says the defendant is not currently complying with the payment plan. I think in practice, you couldn't find civil contempt if someone was complying with a payment plan, because one of the conditions of finding civil contempt is that there has been a failure to pay any portion of the amount due. And that language is in subdivision C5A3, which is on page 4 of the bill itself. Everything else in the bill, from the commencement piece down, those are all technical corrections that are adding subsection headings or adding commas, making grammatical changes. You'll see a hyphen added in here in first class mail. Those are all duplicative to changes in the technical corrections bill. Since this is going to be my segue to you hearing about the fiscal note, under current law, and this is on page 3 in subdivision 4B, the hearing officer can waive the reinstatement fee required under 23 VSA section 675A, in addition to needing to pay the amount due on your judgment. If your license is suspended for non-payment currently, or if your license is suspended for any reason, you need to pay a statutory $80 reinstatement fee. Nothing in this bill is changing that $80 reinstatement fee, but there will be a fiscal impact because fewer people will need to pay the $80 reinstatement fee, and Chris will talk about that.
Is there any space in statute already or that allows people who simply can't pay that to get some sort of waiver?
So under the law that you see up on the screen, and this was something that was, I think, inadvertently repealed in 2016, and then it added back to statute by the General Assembly in 2020, the Judicial Bureau can waive the reinstatement fee or reduce the amount due on the basis of the defendant's driving history, ability to pay, or service to the community, the collateral consequences of the violation, or the interests of justice. So that $80 fee can be waived or reduced at the discretion of the Judicial Bureau.
And what about the late fees? Would that also apply to that? Like, I would just hate to see someone who didn't pay because they couldn't pay and then racked up hundreds of dollars in late fees, just making it compoundingly worse for them.
Yeah, are there late fees?
Excuse me, Mike Smith, Deputy Commissioner from DMV. I know there's a $30 late fee that's assessed. I don't know if that continues to double or get larger.
Okay, so because the way I'm reading this bill, it sounds like that late fee could compound itself. Maybe I'm just reading it incorrectly.
Well, so this isn't doing anything to change anything. So I'm ill prepared to answer your question.
Okay, yeah, no, what confused me is it says the Judicial Bureau, oh, never mind, I'm good. Pay not more than $30. It's the payment plan there. I was reading that as it won't be more than $30 a month at the late fee.
No, that's if you're entering the payment plan, what the highest threshold of monthly payment would be.
Got it. I read that backwards.
Did you explain section 2 again?
Section 2
I
again.
mean, the only part I understand is this act will take effect on passage.
Oh, section 2, yes.
Beyond that, I can't figure.
I had a question too, because I've never seen an effective date section that lays out, this is like a section of the law rather than just an effective.
Yeah, so I would say this is like a combination of an effective date and implementation language.
Yeah.
And it's providing clarification that assume this bill takes effect tomorrow. If you are currently having your license suspended for non-payment, it doesn't change anything for you. If your license has not yet been suspended, but you have a moving violation and you haven't yet had your license be suspended, couldn't then be suspended, despite the fact that the moving violation occurred prior to the act taking effect. And what's not included here, because this bill doesn't do anything for those individuals, is if your license is currently suspended It does not change anything about you needing to pay that $80 reinstatement fee. You'll still be subject to paying the $80 reinstatement fee. So it's kind of drawing a line in the sand, saying
Yeah.
at this point forward, no more suspensions for non-payment. Nothing changes for individuals whose license is currently suspended. But if you're sort of in that in-between area, you've been issued your moving violation ticket, but your license hasn't been suspended yet for non-payment, it can't then be suspended.
I guess I would say the length of your answer suggests to me that it should be elsewhere in the bill besides the effective date.
We could change this to be a section 2 implementation and a section 3 takes effect. on
I
passage.
think that would be helpful, because your explanation helped me understand what it's trying to do, but I think if I'm the average person, I'm trying to figure out what I need to do.
That can certainly be split out. I think that's a good clarifying change.
I don't know that the average person is gonna be reading statute to figure out how to get their license back.
Only on the weekend.
But it gets,
I hear you, yes.
doesn't that get printed on your? Wouldn't that be printed somewhere? I mean, wouldn't that be distributed to people who?
I think it would be sort of up to the Judicial Bureau as to anything being disseminated to individuals whose proceedings were pending, that had that traffic violation that was outstanding, letting them know that they're no longer going to have their license be suspended. But I think given the window of the lengths of the suspensions, because it's 30 days for non-payment unless you pay it sooner, you probably would not even really have enough time for the Judicial Bureau to like do an extensive like outreach campaign. You'll hear from the Judicial Bureau, I believe, because this is what they testified in House Judiciary, that there's going to be a cost in terms of them like changing tickets and the notice information that's on that. But that's not something that I think would necessarily change in a temporary way to address this implementation language. It would just change to say, no longer are licenses being suspended for non-payment.
I'm all for making it clearer in the bill. I want to be clear. My experience of the ordinary Vermonter is that they don't read statute.
Understood, but some do.
Some. No, I'm here to, let's make it clearer, 100%. Was not arguing that point.
So that's it for the walkthrough.
Thank you. Other questions? Thank you very much.
I just have one. I'm confused as an average person. Under F, Cynthia,
Mhm.
where it's collections, can you explain that particular process to me?
So and I think you probably are going to get a more as it is applied in practice answer from the courts. The court administrator can have a third party entity collect anything that's owed. So the fines, the penalties, the fees. And then that would be sort of through a process that's approved by the court administrator. It's just one of the other mechanisms that the court has as a way to collect money that's owed for civil penalties. There's also the ability, and you'll hear Chris talk about this, that most of these are paid, the ones that are not paid sort of when they come due, they're paid through a tax refund. If someone gets a tax refund, that's usually how the state collects the money.
Chris, I'm curious as to what is the third party?
Oh, so I think it's more like the Judiciary is not in the business of serving as a collections agency. So they could contract with a collections agency that would actually like do the legwork on the collection.
Senator Norris, just to answer your question, it's called Odyssey. It's a program that you go to the Vermont Judiciary page and there's a button there that says pay a fine. You click the button that says you're going to an external website and it's Odyssey. And then you click the pay the fine. You type in your ticket number and then you pay the fine there. So I think that's what it's referring to, is that this Odyssey program is what the state contracts with to do collections.
Unfortunately, I've never had to go to the Odyssey website.
And I
You
don't
have
know
a-
if they have
other
something,
people.
Not really an average for month.
it's something that they then utilize for the
Julie,
the
no,
ones
it's
that
really
people are
average
not
money
choosing
to
to
go to
use
Odyssey.
Odyssey.
All right, thank you.
Thank you very much. The next witness is Chris Root from the Joint Fiscal Office, who's done a fiscal note on the bill, which indicates they lose about 200,000 in revenue.
Good morning, Mr. Chair, members of the committee. For the record, Chris Root from the Joint Fiscal Office. Senator Sears read ahead in advance and pretty much summed up my testimony for what's in the fiscal note. Something to keep in mind here is that no provision of H53 would make a violator, for lack of a better word, off the hook for paying the amounts due for their traffic violation or any other penalties that would accrue. What would change from a revenue perspective, though, is if you have fewer driver's licenses suspended, you're going to have fewer reinstatement fees paid to reinstate those suspended licenses. Statute currently provides for an $80 reinstatement fee, which goes to the transportation fund. And there are, I mean, like half of the fiscal note, which I'm not going to read word for word because I think that would be probably more painful for you all than it would be for me. But there's a lot of noise in the data, and something to keep in mind is not every instance of suspension pays that full $80 for the reasons Anthea mentioned about, there's the ability for a hearing officer to reduce or waive in some situations. Sometimes there's more than one instance of suspension behind that suspended license, and then you only pay one fee to reinstate it, regardless of how many individual suspensions may have been involved.
I'm just curious how that can be if it was suspended and then not reinstated. You could get another suspension on top of that?
Yeah, so there could be more than one factor that leads to a license suspension. So you could hit the, it could be due to failure to pay and hitting the maximum number of points, for example. So there could be, and Deputy Commissioner Smith can go into the weeds of how many variables this can take in practice. But there can be situations where a license is suspended for more than just failure to pay.
Right, I'm just wondering, are there then multiple suspensions that require multiple reinstatements?
No, it would be to one reinstatement fee to reinstate the license.
Okay, but multiple qualifying
Correct.
reasons to suspend.
Correct. So we took a look at the estimates of how much was actually collected in revenue from reinstatement fees over the last 2 years, and there is some level of variation there, but a sort of a consistent theme is just over 40% of the unique individual suspensions were due solely to failure to pay amounts due within 30 days. So assume that roughly 40%, 43% of that revenue would be foregone. And that gets you to a ballpark estimate of approximately $200,000 of foregone revenue to the T fund annually. There's obviously some room for variation from year to year. There's lots of variables that go into that. But that's sort of the ballpark in the context of a $300 million annual fund. So it's not a major revenue source for the T fund, but it's worth noting the amount of potential revenue impact.
Senator,
So I was wondering, so I know you might not have hard data for this question, but I was wondering if you could touch on collateral consequences and the money that's also saved from people who are not having their license suspended and they're able to continue working, or they're able to drop their kids off at school. Are you able to touch on that? I know there was a mention of it on page 4.
Yeah. So from a fiscal impact, I can't really touch on that, but I did make a note in the fiscal note that I think some of the public policy rationale for this is exactly what you mentioned, and it's that it can be counterproductive to suspend a license due solely for failure to pay when that is interfering with somebody's ability to earn the income they need to pay. Exactly. So I think that Senator, what you just said, I think in a nutshell is sort of the rationale behind the policy argument here. The other things I noted in the fiscal note that I wanted to bring your attention to is we don't expect this bill would have a very significant impact on operations or administration, because a lot of the back end processes between the judiciary and the DMV for processing these suspensions are highly automated. So DMV would expect to, save some postage and printing costs from mailing fewer suspension letters out. But the impact is pretty insignificant in the context of a $40+ million annual budget. The Judicial Bureau also may have some one-time costs to reconfigure that data exchange between the departments and to possibly reprint some new tickets that have revised information on the back. But that expenditure is expected to be less than $10,000, or relatively de minimis. The other item I flagged as a potential known unknown is what, if any, impact the bill may have on changing behavior, which could impact the timing of collections to court special funds. So I do not make any presumption of whether or not this bill would change anybody's repayment behavior. I flag it as a potential risk, just that if this would encourage more people to enter payment plans, or maybe folks who could otherwise pay promptly within 30 days might not, that again doesn't remove anybody's responsibility for paying those amounts due, but it could impact the timing, especially if things have to go to collections to go through the tax offset process. So I just flag that as a potential thing to keep your eye on, but we don't know definitively whether or not this will have a significant impact there. So those are the real findings of the fiscal note. Does anybody have any questions?
Chris, very good, thank you.
My pleasure. Thank you.
No questions? Great. The next witness is Laura Canty, Chief Trial Court Operations. Good morning, Laura.
Good morning. So I can answer any questions you have. I can just start out by saying that the impact of H53, if it passes on the judiciary, would be pretty minimal. As Mr. Roop mentioned, we would need to order new ticket packets, new ticket books, and change the e-ticket form. It takes about 6 to 8 weeks to get new tickets in, and there would be a printing cost for those, which would not be terribly significant. We would also need to work with our technology service center on some reprogramming to change the automated report that's delivered to Department of Motor Vehicles. Again, that is not expected to be a significant increase to their workload. And if I could just comment on the collections question that was just asked. As mentioned, we contract with third-party vendors for our collections. Currently, we use Alliance One, which is a tax collection or a collection agency. We refer unpaid judgments to them. We also refer anything that has a judgment of over $45 or over, and as long as we have a social security number for the defendant, we can refer those to the tax department. Tax department collections are certainly more effective with Vermont residents, of course. But those are our two mechanisms that we're currently using for collection. The bill notes a contempt proceeding. That's not something that's used. It would be very resource intensive. We have actually stopped incarcerating criminal defendants for non-payment of fines. So I don't think that would be a likely outcome for unpaid traffic ticket. And I'm happy to answer any questions.
Any questions, Laura? Laurie, thank you very much, Laura.
You're welcome. Thank you.
Next is Willa Farrell, the Deputy Director of Court Diversion.
Change my.
You're not a defender general.
Good morning. For the record, my name is Willa Farrell. I work in the Attorney General's Office of Court Diversion and Pretrial Services, and I'm happy to speak in support of the bill. And as Senator Sears referenced, I've seen many changes over the years that the legislature has enacted that have really been beneficial to the people who come to court diversion. And to provide some context, I'll just mention that last fiscal year, there were, I think, approximately 550 people who were referred from criminal division for a license suspension. And in addition, we worked with another 300 or so people whose license was suspended, but not necessarily facing a criminal charge. It takes your third suspension within a 2-year period becomes a crime. Prior to that, the first 2 suspensions are civil violations. So in essence, court diversion case managers are helping people to regain their driver's license, and they serve as navigators in terms of dealing with bureaucracies and helping people to figure out, frankly, how first to identify what are the requirements in order to be reinstated. And for the most part, those requirements require money. And one of them is paying fines and fees. So this change would reduce one of the barriers to license reinstatement for folks. I think it's important to align suspensions with behavior, not with ability to pay, which I think is the essence of what this proposed legislation would do. And I'll just note that there are other barriers to the people getting their license back, but I think this one bill would be one more effort that could make a difference for many Vermonters.
Thank you.
Thank you. Other questions for Will? Well, how many people are currently in that program for license reinstatement?
Well, I don't have a snapshot right now, but I'm assuming the numbers are similar to people who were referred last year. So
Yeah.
I would say, probably 400 to 500 people. And I will say that people don't necessarily successfully complete court, that's the group of people who successfully complete court diversion is most challenging, because for most prosecutors to complete diversion successfully, you have to get your license reinstated. Some prosecutors will accept if you develop an alternative driving plan and there's no indication that you're driving. But it is very difficult for people to, for example, deal with out-of-state requirements, which may be really costly. IDRP is costly. Those are the two main barriers I hear.
It interests me, the out-of-state suspension. We have no
Yes,
control over.
exactly. Yeah. Case managers spend a lot of time on phones trying to get through to other DMVs to find out what is this requirement that needs to be satisfied. So.
All right. Thank you. Next is Marshall Paul, now the deputy defender. Juvenile defender. Office Defender Jim.
Thank you very much. Good morning. We are very much in support of this bill. From our perspective, this deals with a problem that we've seen for years, which is that when people get moving violations, when they get traffic tickets that can lead to license suspensions for failure to pay, they often, those clients of ours often are unable to pay, and they end up getting hit with the criminal charge, which you can get after you have 3 DLS for failure to pay a traffic ticket convictions. And from our perspective, the real problem with that is a lot of these people are people that we all as a society, we want them driving. It's not people who are, because this does not at all affect people whose licenses are suspended because they got a DUI for driving while they were intoxicated, or people whose licenses were suspended for, a negligent operation, something like that. This really only affects those people whose licenses are suspended simply because they don't have enough money to pay the fines that they owe. And to take those people and tell them, as a response to your inability to pay, we're going to make it impossible for you to go to work, go out and find work if you don't already have work. It simply just makes no sense. And really, it's not what we want. We want, those are exactly the people who we want out trying to find jobs, being able to go to jobs, being able to get employment and stay employed, and not be relying on sort of the completely inadequate public transportation system, or rides from friends and neighbors, which is what I always advise my clients who get suspended and ask me, well, what am I going to do? What should I do? I always say, the best bet is try to find people in your community who will support you and help you move around. But this will help to solve some of that problem, and we think that's important. So we support it very much, and that it really does, it's not, from our perspective, going to change anything. The people that we're talking about here are not people who are the sort of scofflaws who just refuse to pay. And to the extent that this would capture those people, there's a safety valve, which is the contempt provision. If somebody's refusal to pay is not based on their inability to pay, and it's simply that they feel like the laws don't apply to them, or they don't want to obey the court order, there is a civil contempt provision to address that. So from our perspective, this is all win and no lose, all gain, all upside, no downside.
That rarely happens.
Really? Yeah.
Nice.
Well, if it's 200,000,
Somebody.
if I want to find something down, it's 200,000. But I think as Senator Sheen said, it's possible that earning capacity, taxes, relicensing or license renewal, those types of things might even make up for it. But people having jobs, if they're suspended, I do worry that there's nothing we can do about out-of-state suspensions. Particularly becomes true for those who live on the border with New Hampshire, Vermont, and Mass and New York, where there's a suspension there. We honor that suspension. But there's little we can do about that, I guess.
Yeah, just a comment if I can.
Yeah.
I appreciate your testimony and a lot of what you said. And I think the thing that's always struck me is somewhat illogical is, these circumstances where somebody gets a ticket for, let's say, not registering their car because they didn't have the funds to register their car, or, they're going 10 miles over the speed limit. And, they get their $150 ticket and they get suspended because they can't pay it. And then, now they can't go to work to make the money to pay for that, not only the first ticket, but then also the suspension. It's just, that loop has never made any sense to me. So yeah, I think this is a good bill. I appreciate what
I
you said.
agree. And frankly, what happens in that loop typically is that people just drive anyway. I told this story on the House side. I am somebody who at one point had my driver's license suspended for failure to pay. I didn't even know it at the time. I had been pulled over. I don't even remember for what, and I paid my ticket. But by the time they received my payment, there had been a late fee, a $30 late fee applied to the payment, which I didn't know about because I moved several times, and so I didn't update my address on my driver's license quickly enough. So I never got the notice that said you owe a $30 late fee, and so they suspended my license, and I drove around for a few years before I then got pulled over for something else and was told you're driving with a suspended license, and had to go through the process of paying the $80 reinstatement fee and all of that. But so it's something that can happen really even without knowing about it.
So just a quick clarification from my point. So this simply refers to civil violations, not criminal violations.
Right. This does not apply to people who get a
CNN, LSA,
Right.
all that stuff there. Okay. All right.
Yeah.
Thank you.
Michael Smith. All right. Thank you, Marshall. Next, we have Michael Smith.
Morning, everybody. Michael Smith, Deputy Commissioner for DNV. There isn't a whole lot left to be said. I think Chris really said it all. The department, we do have a potential loss of foregone revenue of 195,000, I think is what he put in the note. For that reason, we're neutral on the bill. I've been here for many years. I've watched the testimony in this committee and on the House side and seen the work trying to be done to get people back on the road legally so they can avoid the circle. So we are supportive of that. The one thing that I've asked, and it hit me while I was listening to Dia talk about the effective date. So using her example of if the bill passed today, We've already issued a whole bunch of suspension orders that have a 20-day lead time. So if possible, I'd ask, could the bill be effective 20 days after it's passed? Mainly from an operational perspective of trying to undo all of those suspensions that are in that pending category. It was a 20-day period. If that could be done, that would be appreciated. A month, maybe. 20 days would be what we need exactly. If you could do a month, that would help.
I'm just thinking we don't normally count it out in days.
So how often do you send out suspension notices?
Every
So that we
single
don't, every single day.
Correct, and that's why.
We gotta get
when I
ahead of the
heard-
20 days then, right? Depending on when the bill.
Right.
Yeah.
So the 30 days would allow us to work with the judicial bureau and stop that stream of transmissions. And let the others kind of play out.
So just one more time, the technical language or the specifics, can you give me what it is that you were hoping for effective? Yeah.
The effective date to using, what you had said 30 days after the bill is passed. That will allow us to get outside of all of the pending suspensions, as well as giving basically 10 days to work with the judicial bureau to shut the stream down.
Thank you.
You're welcome.
Wow, we're burning through the agendas.
Michelle is available, so
Is that for H-148?
I think I'll email and tell her to come down now.
Let's do it.
Sounds good. Did we, were we gonna hear from Willa Farrell? I don't see her on there, but she's on
We
the,
already did.
oh, yeah, sorry. Sorry about that.
Michelle's gonna come down
Thank you.
now, because we're almost ready.
Okay. Well, we are done. That was quick.
Yeah.
Is there anything else we need to know about this bill?
Technical change to the effective date to 30 days after the bill is passed.
Yeah.
And I'll split section 2 into its own implementation section. So there'll be a section 2 with all the implementation stuff, and then section 3, the effective date is actual take effect 30 days after passage.
Okay.
And I'll have that for you, I think tomorrow morning is when we were planning on taking this up again.
All right. Well, it shouldn't take more than 15 minutes to vote it out. I will be in Bennington, but I can still vote too. Sounds good to me.
I don't know where I can all this go.
What?
No.
This simple little bill.
I'm good.
I seek my conscience.
My constituents.
She's on her way.
I don't know if you can join us, we can have an African consultation.
Did you ever see the movie, Brother Where Art Thou? With,
What?
Brother Where Art Thou?
Oh, yeah.
Where they're soggy boys are singing up on stage, guy comes in and takes
Why
the
don't we,
microphone and says,
take
"Is
it?
you is."